All right, so today we're going to talk about the preliminary considerations and procedures. So think of this as stage setting for the entire litigation process. So before we ever even draft a complaint, appear in court, or even officially take on a client, there are certain questions that have to be answered. Like, does this client actually have a legal case? Can it be filed on time? Is it practical to even pursue? And just as importantly, is it ethical for us to accept this matter? Okay. So we're going to talk about like the legal, practical, and ethical sides of litigation. And as you will see, these preliminary considerations, they're not just small details. These are the gatekeepers to decide whether or not a case is going to move forward or never even make it past, the front door. So there are three key questions that every lawyer and paralegal has to consider before a lawsuit can move forward. Okay. We're looking for the cause of action, the time limitations, and the ethical considerations. Now let's talk about the first and the most fundamental question. Does a cause of action even exist? So a cause of action is the legal right to bring a lawsuit. It is essentially the framework that gives the plaintiff standing to ask the court for relief. Without a cause of action, you don't have a case. You might have a story, you might have a complaint, you might even have a legitimate grievance. But unless the law recognizes it, the court can't offer any kind of remedy. Okay? Now, let's talk about negligence, because this is one of the most common civil causes of action. The law in these cases looks for 5 distinct elements. And if you're missing one of these, the claim gets completely tossed. Now, the first is duty. The defendant must have owed the plaintiff the duty of care. Okay. So this duty can come from laws, relationships, circumstances, those types of things. So like a driver owes a duty to follow the laws for traffic and operate their car safely, right? Doctors, they owe a duty to provide treatment to meet the professional medical standards. A grocery store, they owe a duty to keep their aisles free from hazards. So without a recognized duty, there is no starting point. Second is the breach. So once a duty is established, the plaintiff has to show that the defendant actually breached their duty. So like a driver who runs a red light, they breach their duty of care. Okay. A doctor who leaves a sponge or a needle or something like that inside of a patient, they breach their duty to perform, the procedure competently. A store that ignores a spill on a floor, they breach their duty to maintain a safe premises. Next is the actual cause, and it's also called the cause in fact. And this element essentially asks, but for, the defendant's actions, would the plaintiff have been injured? And this is not always, straightforward, but it usually is. So like if a driver crashes into another car because they ran a stop sign, the accident is the actual cause of the breach, okay? There are some more like complex cases where there's multiple causes. The line in those cases becomes more blurry, but you'll learn about those in torts. All right. Next is proximate cause, and this is about foreseeability. So even if the defendant's actions like set something in motion, they have to ask, was the harm that actually occurred a reasonably foreseeable result of that action? Okay. So this element limits liability so that the people aren't held responsible for some sort of like bizarre, far out, consequences that happen. All right. And actually, one of the most famous cases here, and you'll hear this one again in torts, but it's Palsgraf versus Long Island Railroad. And it's where you have a man who was carrying fireworks. He was helped onto a train by employees, and his package fell, and it exploded. And it knocked over the scales that was at the other end of the platform, and they fell on Helen Palsgraf and injured her. And so the court ruled that the railroad was not liable because her injuries were not a foreseeable result of helping a man simply get on a train, okay? And this case still shapes how we think about proximate cause. And last is the damages. So a plaintiff has to show that there is some sort of actual legally recognizable harm. Okay, it could be physical injury, a financial loss, emotional distress, but it has to be something that the law acknowledges. And without the damages, there is no recovery. So even if all the other elements are satisfied, it doesn't matter. Okay, so let me pull it all together for you. And I want to use something that's absolutely ridiculous, because that's one of the things I love about torts, is that you can have something that really kind of triggers that moral compass, because you're like, what? That's so dumb. But it's something that shows, I don't know, I guess it just shows how something simple could actually be a court case. But imagine you have, say, a student on campus, and they throw a snowball as a prank from their dorm window, okay? Hits the pedestrian on the sidewalk. Pedestrian stumbles, drops their brand new iPhone, cracks it. Okay. Do we have a cause of action? Well, the student had a duty to not carelessly endanger somebody that's going by, and throwing that snowball breached that duty. Okay. Snowball caused the stumble. So that's the actual cause. The damage to the phone was foreseeable, because, I mean, if they stumble, it's natural to drop things. So that's the proximate cause. And they sustained actual damages, which was the broken phone. So all 5 elements are met. So yes, there could be a cause of action. But let's tweak it just a little bit, okay? So suppose the snowball startles the pedestrian, who then bumps into another person, who drops a glass bottle, and it shatters and it cuts somebody's, hand across the street. Was that injury foreseeable? That one's most likely not. Okay. So this is where that proximate cause is going to come into play and stop a case like in its tracks. Okay. So like a court might say that the injury to the person across the street was entirely too remote to hold the original snowball thrower liable. Okay. But regardless, the lesson here is clear. When determining whether a case can move forward, we have to confirm the existence of the cause of action. That is the foundation. Without it, we don't have a lawsuit. We only have essentially frustration with no legal remedy. All right, so let's say we've ticked that first box. We've checked it, okay? We know that there is a valid cause of action that exists. The next question is more practical. It says, even if the law says the lawsuit can be filed, is it wise to actually file it? And this is the issue of feasibility. Feasibility essentially asks us to step back from that pure legal analysis and to think strategically. Lawsuits take time, they take energy, they take resources. So just because you can file a lawsuit doesn't always mean that you should, okay? And so attorneys, and by extension paralegals, they have to help clients weigh the potential benefits against those very real costs. And that's the very first consideration. It's the cost of litigation. Again, lawsuits are expensive. You have filing fees that can range from a few $100s on up to thousands, okay? And it depends on the jurisdiction. It depends on how many defendants you have, all kinds of things. Then you have discovery, which is gathering the evidence. You're doing depositions, interrogatories, document productions, and these cost more. You have expert witnesses who are often essential in, say, like a medical malpractice case or a product liability case, and they can charge hundreds of dollars per hour. So even if routine litigation exists, it can run up bills that actually far exceed any kind of actual damages that could be had. Okay. So imagine that you have a client who comes in and they have, say, a slip and fall claim. They tripped on a cracked sidewalk, they sprained their ankle, and their medical bills are $500. The cause of action is clear. Okay. The property owner likely owed a duty to maintain the sidewalk, and the breach actually cause the actual damages. But the cost of pursuing that lawsuit could possibly be, say, $10,000 in attorney's fees and filing fees and expert testimony and all that stuff. So does it make sense to spend $10,000 to recover $500? Probably not. So from a feasibility standpoint, the lawsuit itself may not be worth it. Now, The second factor is the amount of damages that are suffered. The larger the damages, the more sense it makes to proceed. So, for like a minor injury with small medical bills, it might be best to take it to like small claims court, which would probably be more appropriate. But for something that has like bigger injuries or catastrophic injuries, like think of somebody who was injured like during a surgery due to very clear negligence with lifelong medical expenses, those damages are so significant that the high cost of litigation is definitely justified. And the third factor is one that probably most people do not think about, and that is the defendant's ability to pay. The bottom line is that winning a lawsuit is only half the battle. Okay. You still got to collect the money. And if the defendant has no assets or no jobs, or it was a car accident or something and they had no insurance, well, that victory might seem a little meaningless. So for example, if you have a client who comes in after a car accident where they were hit by an uninsured driver, the damages, they're probably substantial. Like you're looking at medical bills, you're looking at a car that might be totaled, lost wages, all those kinds of things. But if the driver is unemployed, has no assets, lives in a rented apartment, and again, we've already established no insurance. Even if the client wins that lawsuit, collecting that judgment would be nearly impossible. Okay. So the attorney will explain, that while the cause of action is valid, the lawsuit itself is just not feasible because the recovery is unlikely. And that is something that can be very difficult for clients to feel. They may feel wronged. They may want their day in court, but part of an attorney's role and your role as a paralegal in supporting them is to help the clients make informed decisions. And sometimes the best advice is not to pursue a case. Okay, just don't do it. Or explore other options like mediation or a settlement or last resort, walking away. Okay, but feasibility is going to kind of act as like a second filter here. Again, the law may provide a remedy, but if the cost outweighs the benefit or if the defendant cannot pay, then litigation itself may not be the wisest path forward. Now let's talk about something that may feel uncomfortable at first, and that's turning down a case. Clients will come into a law office believing that they have a slam dunk case. They're emotionally invested. Sometimes they're financially desperate. Sometimes it's just they're convinced that justice demands this lawsuit to happen. But sometimes the ethical and professional answer is simply no, not doing it. Attorneys, and by extension, their paralegals, have to recognize when taking on a case is just simply not appropriate. And that could be because the claim isn't legally valid. The damages might be too small to justify the cost, and it could be because the defendant lacks the ability to pay. But it can also be because the lawyer has a conflict of interest or doesn't have the competency to handle the matter. But whatever that reason is, saying no can be just as important as saying yes. But how you say no, it matters, okay? So when they decline a case, it should be communicated clearly and ideally in writing. Phone calls, they leave room for misunderstanding sometimes. A written letter, it's going to set out that decision plainly and create a record for the lawyer. And this letter is often called a non-engagement letter or a declination letter. Now, here is a very critical part because attorneys should avoid giving personal opinions that could later be misinterpreted. For example, saying, you don't have a case, that might come back to haunt the lawyer if another lawyer files the lawsuit and wins. Instead, the professional phrasing is, I am unable to take your case. That avoids drawing conclusions about the merits of the claim. Now, another essential element in turning down a case is advising the client of the statute of limitations. So even if the lawyer is declining representation, the client still has the right to seek another attorney. If they're not warned about the filing deadline and they miss it, they may turn around and sue the original lawyer for malpractice, arguing that the failure to advise them caused them to lose their claim. Okay. So for example, if you have a client who talks to an attorney about a potential malpractice claim against a doctor and the lawyer decides not to take it, but fails to warn the client that the statute of limitations is going to expire in a few months, you might have a client who waits, assuming that they have plenty of time. And then by the time they find another lawyer, the deadline is passed. So not only is the malpractice case gone, but now the original lawyer can face their own malpractice suit because they failed to advise about the deadline. Okay. Now, as a paralegal, you might not be the one who is making the ultimate decision to decline a case, but you probably are going to be the one drafting the letter. So your role is crucial in making sure that the language is professional, it's clear, and it's protective of both the client's rights and the firm's liability. Okay. So imagine you're drafting a letter. Okay. And a potential client has come in, slip and fall case, damages are minor, the store has no insurance. Okay. And the attorney has decided to decline the case. How do you word that letter? Okay. You would not want to write, well, we don't think you could win. Okay. Because that's giving a legal conclusion. Instead, you would want to write something like, after careful consideration, our firm will not be able to represent you in this matter. Please note that your claim may be subject to statute of limitations, and you should probably consult another attorney if you wish to pursue it. Okay? That wording is going to accomplish three things. It's declining it clearly, it's avoiding offering an opinion on the merits, and it's informing the person of the urgency created by the statute of limitations. Okay? So again, turning down a case isn't just about saying no. It's about saying no in a way that is professional, it is ethical, it is respectful. It's protecting the client and the attorney and even you from any kind of future problems. So since I already touched on it a little bit, let's talk about that very unforgiving aspect of civil litigation, and that's the time limitations. So the law requires that every lawsuit be filed within a certain period of time, and that's known as the statute of limitations. Now, these are not suggestions. They are not guidelines. These are hard and fast deadlines. So if the case is not filed within that specified time frame, the court will dismiss it, no matter how strong the claim may be, okay? And the reason for these rules is twofold. So first is that they promote fairness to the defendants. So imagine being sued for something that happened 20 years ago. By then, your witnesses may have died. Documents may have been lost. And I can tell you that memories will definitely have faded some, okay? So the statute of limitations is going to protect the defendants from being forced to defend against a stale claim, okay? Second is they encourage efficiency. The law doesn't want people sitting around on their rights indefinitely, okay? So the plaintiffs are expected to pursue their claims diligently, all right? So, I clicked that too early. But suppose that a car accident, occurs, say, on January 1st, 2023. And let's say that the statute of limitations for personal injury is 2 years. That means that the lawsuit has to be filed by January 1st, 2025. So if the complaint is filed on January 2nd, even though it's only 1 day, the case will be dismissed. It doesn't matter that the defendant ran a red light, that the plaintiff was seriously injured, or that they have evidence that is super crystal clear. Once that deadline has passed, that claim is dead, okay? There are countless number of cases where you have very strong claims, and they were lost simply because somebody miscalculated the statute of limitations. And courts will routinely say things like, hey, we sympathize with the plaintiff, but the law is clear. The deadline has expired, all right? And let me give you a real world case. There was a case, it was the Board of Regents versus Tomaneo. And the U.S. Supreme Court emphasized the importance of the statute of limitations, ruling that federal courts must apply the state statute of limitations in certain civil rights cases. That decision reinforced, again, that the deadlines are not flexible. They're absolutely fundamental, okay? So imagine that you are, working in a firm and you have a client who comes in, 2 years after a car accident saying, well, I've been thinking about suing, but I wasn't sure, and you check the statute of limitations in your state and you realize that that deadline passed last week. What do you do? Someone has to explain very gently but clearly that the court will not allow the case to proceed. This is where the role of you comes in. You have to be detail oriented in knowing that aspect of it, but you also have to be compassionate because, that part's important. But the bottom line is that time is not just important in litigation, it is decisive. Okay? You can have that perfect cause of action, clear liability, and you can have tons of damages. But if that case is filed too late, all of that is completely meaningless. Okay? The statute of limitations is going to shut the courthouse doors, period. Okay? Now, let's talk about calculating the deadlines because that's not always straightforward. In some situations, the law recognizes that it would be unfair to stop the clock right away. This is where the concept of tolling comes in. So tolling means the statute of limitations is paused or it's delayed. So the clock is not ticking for a certain period of time, either because the plaintiff's situation or because of the defendant's behavior. Okay, but once the tolling period ends, the clock starts running again. So let's look at some common examples. For example, minors. Okay, if the plaintiff is under the age of 18 when the injury occurs, most states do not require them to file a lawsuit immediately. Instead, the statute of limitations is tolled until they reach adulthood. And at that point, that normal period begins to run. So like a 15-year-old who's been badly injured in an accident, in that state, let's say the statute of limitations is 2 years, okay? And let's say it happened on January 1st, 2023. Because the plaintiff is a minor, their 2-year clock wouldn't start until their 18th birthday in 2026, which means that they have until 2028 to file suit, which effectively gives them 5 years rather than 2. But the rule is intended to make sure that minors aren't denied justice simply because they weren't old enough legally to file the lawsuit at the time of injury. Okay? Hopefully that makes sense. Another example is mental incompetency. So like if a person is not legally competent due to some sort of mental illness or disability, then the statute can be tolled until that person regains their competence or until a guardian is appointed on their behalf. All right? This rule recognizes that someone who cannot understand their legal rights should not be penalized for failing to exercise them. Okay? So let's say that you have someone who has like a traumatic brain injury from an accident that leaves them mentally incapacitated. And 2 years later, they regain enough capacity to manage their own affairs. In that state, or in a lot of states, the statute of limitations would be tolled during the period of incompetency. Again, giving additional time to file that lawsuit. You also have where defendants cannot be located. And some states will toll the statute if the defendant has been absent from the state or is actively evading service of process. And the reasoning in this case is very simple. A defendant should not be able to run out that clock simply by hiding or disappearing. Okay? So if you have someone who's injured by a defective product and wants to sue the manufacturers, but the company then relocates overseas, like closing its U.S. office, that statute may be tolled until the company can be properly served. Okay? In the same vein, like if a car accident defendant flees the state to avoid being sued, many jurisdictions are going to pause that statute until they return. And or they can be served through like alternative means. Okay? You also have situations too where you might have someone who is making defamatory comments. And let's say they make the first defamatory comment on, which falls under personal injury, by the way. So if the statute is 2 years, let's say it starts on January 1st, 2023, right? You would think, hey, you have until January 1st, 2025, right? But if they turn around on June 1st, 2023, and they say something else that's defamatory, the clock starts from there. It still allows you to get the, you can include like the previous act, but it just starts the clock again. Again, if they wait until a year later in, June 1st, 2024 to make something else defamatory, again, the clock starts over. So this clock will constantly be tolling. I hope that all this makes sense. So, if you have, say, and kind of pulling all this together, if you have like a 16-year-old who's injured, like in a bike accident that was caused by a reckless driver who then like leaves the state to avoid responsibility, the teenager is going to remain a minor until 18. Okay. In this case, we have tolling on two levels. You have the plaintiff who's a minor, and then you have the defendant who's absent. So when the teen turns 18 and the defendant is located, that's when the statute will begin to run. But, without having tolling in place, a plaintiff like that might have been completely denied, their chance to sue. So just remember that the statute of limitations, they are strict, but tolling does introduce sort of a measure of fairness. It protects like the vulnerable plaintiffs, like the minors and mentally incompetent, and it's going to prevent defendants from, playing the system by vanishing. Okay. And again, you as the paralegal will often be the one who's going to be doing the math. You're going to track dates, you're going to calculate deadlines, and you're going to spot situations where tolling applies. And a single miscalculation could cost a client their entire case. So being precise is absolutely critical. Now, beyond the statute of limitations, there are two other doctrines that are important. We have the claim statutes and laches. Okay. Claim statutes apply when suing a government entity, and these are much more strict, and they often require the plaintiffs to act very quickly. So, like in some states, a person who's injured by, say, a city bus accident, they may have as little as 90 days to file a notice of claim, I should say, because you can't just sue the government without their permission unless it falls under one of the exceptions. So you file a notice of claim first. But you miss that deadline, the case is barred, even if the general statute of limitations hasn't expired. Then there's laches, and that is an equitable doctrine. And unlike the statute of limitations, which are very rigid, laches is flexible. This is an affirmative defense. It is going to bar the lawsuit when a plaintiff unreasonably delays in bringing the case, and it would now make it unfair to the defendant. So let's say that you have somebody who has a property line dispute with the neighbor, right? Neighbor builds a fence that crosses a few feet over into your client's yard. Your client saw it, but said nothing for, say, 20 years. Okay. Now property values are increasing, and, your client's mad about it. They want to have that fence moved. Well, the court is likely going to dismiss that claim under laches, reasoning that it's unfair for you to wait 20 years and for property values to go up when the neighbor relied on your silence. Remember that in the law, silence is an affirmative answer. If you say nothing, the courts will assume that you have agreed with whatever it is. Okay. But laches, laches still reminds us that even when the clock hasn't officially run out, fairness does still matter. So courts don't just look at deadlines, they do also look at conduct. All right, so now that we've talked about whether a case is legally and practically viable, let's talk about those ethical obligations an attorney faces when deciding whether to accept a case. This is where the ABA model rules of professional conduct are going to come into play. Now, these rules don't just guide lawyers in court. They set the standard for whether an attorney should even agree to represent a client in the first place. And one of the first questions that a lawyer must ask about is competency. Do I, as the attorney, have the knowledge and the experience needed to handle this type of case? If not, can I reasonably gain that competence, or can I work with another lawyer who has it? So, for example, if a client comes in with a very complex patent law case and the attorney only practices family law, taking that case without help would be risky and unethical, okay? The model rules specifically state that a lawyer must provide competent representation, which means more than just trying hard, okay? It means being able to apply the right knowledge, the right skills, and the right preparation to the matter at hand. Next is frivolous claims. The rule prohibits an attorney from bringing a case that lacks any kind of legal or factual basis. So, a frivolous claim is one that is not supported by existing law or by a good faith argument to extend or modify or overturn the law. Okay. In other words, basically, it's a claim that is brought to the court simply to harass or delay or burden another party. Okay. So again, let me give you a new one. So let's say that you have someone who wants to sue their neighbor because they give funny looks, when they walk out to their car. It doesn't matter how passionately the client feels. You can't sue somebody for looking at you funny, So if the lawyer filed the case anyway, knowing that it had no chance of success, it would be considered frivolous. And not only would the court likely dismiss it, but the lawyer could also face sanctions or even disciplinary action for abusing the system. Now, I do want to throw in a little nuance here. What if the claim is weak, but it's not entirely baseless rather? Attorneys are allowed to bring novel claims if they are backed by a good faith argument for changing or extending the law. So, for instance, years ago, you had cases that were challenging same-sex marriage bans. Those were viewed as weak under that existing law, but lawyers pursued them with the aim of changing the precedent. And that's different from filing something that has no foundation whatsoever. Now we talk about conflicts of interest. This is a major ethical barrier at the intake stage. And a conflict is going to arise when the lawyer's representation of one client would be directly adverse to another client, or when the lawyer's own interests create some sort of significant risk of limiting their ability to represent the client effectively. Okay. So suppose you have a lawyer who's approached by a wife who wants to file for a divorce. The lawyer already represents the husband in business matters. So even if the husband's business dealings are unrelated to the divorce, the lawyer's loyalty to him could impair her ability, or the attorney's ability rather, to advocate zealously for the wife. Okay, that's a conflict of interest. All right. Another example might be a law firm that represents a large insurance company. So if an individual client comes in wanting to sue that same insurance company, the firm may not be able to take the case because of its existing relationship. Even if different lawyers in the firm would handle the matter, the conflicts still exist at the firm-wide level, okay? And conflicts aren't just obvious all the time. They can be more subtle. You might have a case where a lawyer is offered a case maybe against their brother-in-law. Or the company the brother-in-law works at is maybe a high-level executive, right? Even if the brother-in-law isn't personally involved in the case, the lawyer's family connection could create a perception or even a reality of divided loyalties, okay? And when conflicts are identified, sometimes they can be resolved through informed written consent by the clients that are involved. But other times you have conflicts that are so fundamental that the lawyer simply has to say, I can't take the case. Okay. So again, ethical considerations in accepting a case, it is more than just whether the lawyer can take the case legally and practically. It should also be asking whether or not the lawyer should take it. We have competency, the avoidance of frivolous claims, conflict of interest, all of those things should play into the decision. And a failure in any one of those areas doesn't just put the lawyer at risk of discipline. It really undermines the integrity of the justice system itself. All right, so let's say that the attorney has agreed to represent the client. Those ethical duties don't stop at intake. They actually expand, okay? So once the attorney-client relationship is formed, the lawyer they're bound by a whole new set of responsibilities that are designed to protect the client and the integrity of the legal system. And one of the most important is the duty to communicate, okay? Clients do place their trust in lawyers, often during very vulnerable times, stressful times of their lives, right? Whether it's a car accident, a divorce, contract dispute, whatever it is, clients want and deserve to know what is happening with their matter. Okay. And the ABA model rules, and specifically Rule 1.4, requires attorneys to keep clients reasonably informed about the status of their case and to promptly comply with any reasonable request for information. And I know that sounds simple, but in practice, it is one of the most common areas where lawyers fall short. So, what does this even look like? Let's say you have a client who leaves 3 voicemails over the course of 2 weeks asking for an update on their case. Lawyer's busy, court's slow to act, nothing significant's really happened, right? And the lawyer just decides they don't want to return the calls. From the client's perspective, that silence can feel like abandonment. So even just sending a quick message of, hey, nothing new has happened, but I'm watching the case closely, could be enough to prevent a complaint. Now, oh, sorry, I have these out of order. Let's talk about confidentiality. So the duty of confidentiality is one of the most it's a cornerstone of the attorney-client relationship. Rule 1.6 requires lawyers to protect all information relating to the representation of a client unless the client has given them informed consent or disclosure is required by law. Okay, so this duty is more broad than the evidentiary attorney-client privilege, which only applies to those courtroom settings. This confidentiality applies to everything the lawyer or paralegal learns in the course of working with the client, regardless of where it's said or how it's shared. Okay, so think about how broad that is. If you have a client who casually mentions during a meeting that they're struggling financially, that information is protected just as much as any kind of direct discussion about the facts of the case. Okay, and confidentiality breaches can happen in the most subtle ways. You might have, say, a paralegal who is working on a case, a divorce case, right? And they just casually mention at dinner, well, we've got this client whose husband is hiding all of his money in a secret account. Even without names, the details could identify the client. All right, that's a breach of confidentiality. Another example is leaving client files open on a desk in a shared workspace where unauthorized people could see them. All right. In today's world, we also have confidentialities issues that are tied to technology. Think about the email. Have you ever hit reply all by mistake? If you have a confidential email chain that accidentally goes to the wrong recipient, well, that could expose sensitive client information. Or working from home, if somebody, a paralegal uses a personal laptop without encryption to store client documents, and that laptop gets hacked, then confidentiality is compromised. All right. There's also instances where you have attorneys or staff who talk too freely in public spaces. Imagine you've got 2 lawyers who are riding in the elevator together after court, and they're discussing, strategy for their client's upcoming hearing. If another person in an elevator happens to know the opposing party, confidentiality of that discussion is gone. Okay. So the duty to maintain this confidentiality, it's absolute and it's ongoing. Okay. It doesn't end when the case is over or even if the lawyer client relationship ends. All right. A lawyer can't ever decide, well, I don't represent them anymore. I can share what I know. That protection lasts indefinitely. I'm so sorry. I got those out of order. I had to start a whole new slide just so that I didn't have to go back and re-record that other one. So let's talk about this one at the bottom. Cannot communicate personally with the opposing party. It's if they're represented, by the way. And why is this even important? So this rule exists to protect the integrity of the attorney-client relationship that exists on both sides. So once someone has hired a lawyer, the law presumes that all substantive communication has to flow through the attorney. So if one attorney bypasses opposing counsel and talks directly to the client, it puts that client at risk of being pressured or tricked or even misinformed. And it undermines the role of the client's own lawyer. Okay. So suppose you have a lawyer who represents a tenant in a landlord-tenant dispute. Well, the landlord has his own lawyer, right? If the tenant's attorney picks up the phone and calls the landlord directly to negotiate a deal without going through the landlord's attorney, that's an ethical violation. It does not matter if you have an attorney who thinks, well, this will be faster, or the landlord seems reasonable. The rule is still, it's absolute. You do not have any direct communication with a represented party. All right. Now, let's have a nuance here. This restriction applies to attorneys and it extends to their paralegals and staff that's under their supervision. So you, as the paralegal, if you were to call the opposing party directly to ask questions, again, it's considered the same as if the attorney had done it themselves. All right. So if you're working on a personal injury case and you know the opposing driver has an attorney, but you want to confirm details about the accident or ask them about their insurance coverage, and you call the driver directly, it might feel very harmless, right? But in reality, it's a serious ethical breach. The opposing driver is entitled to rely on their attorney to communicate on their behalf. You've just basically undermined that protection, okay? The only exceptions are going to occur when the other party is not represented by counsel. And in that case, lawyers and paralegals may communicate directly, but there are still some limits that exist. They have to clarify that they represent the opposing party's adversary, and they cannot provide any kind of legal advice to that or that unrepresented person. Okay, so even then, these communications, they still have to be handled with a lot of care because we want to avoid, confusion. And let's just take a second and kind of tie that back into client communication. Imagine that you have a client who calls you up frustrated and they're like, I just want to pick up the phone and call the other side myself. And you'll have that. I promise you, you will have that. Clients often feel like this is going to be faster. It is your job as part of the legal team to explain why that's not in their best interest. This rule exists to shield them from any kind of accidental missteps that could harm their case in the course of that phone call. Okay? And it just period. All right? But again, once the case is accepted, the lawyer's ethical duties are going to expand in those three key directions. They have to keep their client informed. They have to safeguard that confidentiality, and they must never, and that includes their staff, communicate directly with the represented opposing party. Again, these duties are to build, kind of walls of protection around that attorney, client relationship, and to ensure, that fairness within the adversarial system. All right, so now we're caught back up on that. All right, so continuing our discussion of ethical obligations once the attorney takes the case, let's talk about some areas that may not grab as many headlines as confidentiality or communication, but they are just as critical. You have the honesty to the court, fee arrangements, fee sharing, and the handling of client funds. Now, first is the obligation of truthfulness to the court or the truthfulness to the tribunal. So under the model rules, a lawyer must never knowingly make a false statement of fact or law to the court. And that might sound obvious, but I can tell you that the pressure of litigation can tempt lawyers to kind of shade the truth, okay? So for example, imagine an attorney who knows that a key document was filed late, but argues to the judge that it was submitted on time. That's more than advocacy. It's misrepresentation, okay? And this conduct not only damages the lawyer's reputation, but it can result in sanctions as well. You can have contempt findings, even disbarment, okay? So the system it relies on that honesty to function. So when lawyers cross that line, that trust kind of erodes, people's feelings about the entire process. Now, let's talk about fees. Only the attorney can set the fee arrangements with clients. And the fees have to be communicated clearly, again, usually in writing, so the client understands basically how they will be charged. So is it hourly? Is it a flat fee? Is it a contingency arrangement? Failure to clearly define fees is one of the fastest routes to a dispute and a bar complaint, okay? Imagine a client who thinks that their attorney is working on contingency. And if you don't know what contingency is, that is where they take a percentage, and it's usually 33% ish. I should say 33% ish, up to like, I think 35% of of winnings. Okay. So if you have a client who thinks that their attorney is working on contingency, so again, no fee unless they win, but the attorney is actually intending to bill hourly. When that first invoice gets to the client, they're going to feel, blindsided and betrayed. So this is why the clear communication about the fees from the very beginning is very, very essential. Then there's rules about fee sharing. Attorneys cannot share legal fees with non-lawyers, and that includes paralegals. Why? And this doesn't include bonuses, by the way, but it's because fee sharing blurs the line of responsibility, and it can create incentives that kind of undermine independent judgment of the attorneys. So if you have, say, a paralegal, a firm who's told a paralegal, hey, you'll get a percentage of whatever fee this case brings in, well, that arrangement could pressure the paralegal to act in ways that might cross the line into unauthorized practice of law. Okay? Paralegals have to be compensated fairly for their work, which is through salary and hourly pay and bonuses, and not through the share of legal fees. And then we have probably the most important thing, and that is the client trust accounts. These are called IOLTA accounts. It's IOLTA. It's the interest on lawyer trust account. And these accounts, really, they're sacred in the practice of law. Attorneys are frequently required to hold the client's money in trust, okay? Whether it's a retainer, it's a settlement fund, it's proceeds from a real estate closing, no matter what it is. The rule is simple. The client funds have to always be kept separate from the lawyer's own money, okay? That includes the practices like operating account. This is known as the prohibition against commingling. Now, these violations are taken super seriously, all right? So if you have a lawyer who deposits, say, client settlement money into their personal account, just for a few days, they'll transfer it back, right? Even if the lawyer eventually moves that money into the right account, that temporary mixing of funds is commingling, and it's a violation. In some cases, lawyers, who have quote unquote borrowed, client money, they've been disbarred, even if they repaid it, because the act itself shows untrustworthiness. All right. Now, there's also cases where attorneys misuse trust funds outright. So you might have an attorney who might withdraw money from a client trust to pay office rent or personal bills, promising like, I'll replace it, when business picks up or something like that. It's not just unethical. That's theft. And the bar associations will definitely treat it as such. I can promise that. Mismanagement of trust accounts is one of the most common reasons that lawyers will lose their licenses. And you, as the paralegal, you might not personally control the trust accounts, but you will often, do things to help track like client retainers and the settlement distributions and the escrow balances and things like that. So your accuracy and your vigilance, they're just as critical, okay? So if you notice an inconsistency in client funds and you bring it to an attorney's attention, it's not just protecting just the client, but also the lawyer's license, okay? So again, just to wrap up, after the case is accepted, those lawyers' responsibilities, ethical responsibilities, they go beyond client care and communication. We're now extending that truthfulness to the court, clarity in those fee arrangements, no fee sharing with non-lawyers, and like very scrupulous management of client funds, okay? And I know these might sound, like dry matters, but they do all kind of go to the heart of the profession's integrity, especially the financial part. A lawyer who mishandles client money or even just appears careless with it, they risk not just losing their case, but their entire career. Now, I talked a little bit earlier about confidentiality as kind of being like that, one of the main like bedrock duties that lawyers and paralegals owe to their clients. And again, in the past, this usually just meant like locking filing cabinets, avoiding gossip and things like that. But technology is now woven into every part of legal practice. So now the risks are far greater and more, complex. And I talked earlier about how, one use of like technology, which was like the emails to, hitting reply all. But let's talk about you've got, emails to clients, you've got texts about scheduling, you've got online portals for filing documents, you've got cloud storage for discovery, and you even have video conferencing for hearings that was now, that's now more common thanks to COVID. Every single one of those tools can absolutely make the practice of law more efficient, but it does also carry like its own potential pitfalls when it comes to confidentiality and client communication. So let's start with cell phones and emails, which I did talk about a little bit earlier. But have you ever sent a text to like the wrong person by mistake? You can have an error that's happening, like with an email attaching a client's settlement agreement or medical records, things like that. Suddenly, you have confidential information in the hands of someone who should have never seen it. Okay. So, even something as simple as leaving your email open on a shared office computer can create exposure. Another risk comes from public Wi-Fi. Suppose you're working at the coffee shop. You connect to the free network. You want to send the client a quick update. If that Wi-Fi isn't secure, then hackers could intercept that message. So that's why a lot of firms like absolutely it's off limits for staff to have access to sensitive files outside of the office unless they're on a VPN. Um, you have the cloud storage raises its own issues. You have law firms that use cloud services to store, the client files because it does make collaboration easier. Those files, are safe, but they're only as safe as the security measures of the cloud provider. So if the provider experiences a data breach or like if an employee doesn't follow proper password protocol, then confidential client information could be exposed. Okay. A famous example of this occurred when law firm documents in the Panama Papers leak were compromised through like some lax email security. If you don't know what that is, you should go look it up. But that breach didn't just harm the firm's clients, like it was kind of an embarrassment to the whole legal profession, like worldwide. Um, Texting, again, it's an ethical issue. You have clients that now increasingly prefer text messages, over phone calls and emails. But text messages themselves are rarely encrypted and they can easily be read by someone if they have access to the phone. Or if you have somebody who has an Apple phone and maybe an iMac, you can put iMessages and they sync up. So you see the same thing. So if you have somebody who's sitting at the computer, they could see that. Um, you know, what happens if they're sending if you're sending a text to somebody about an upcoming deposition to a client's like shared family phone or something, and the spouse who might be the opposing party reads it because maybe it's a divorce that's happening. Again, you have confidentiality that's instantly broken. You have video conferencing that presents challenges. Again, during the pandemic, Zoom hearings and client meetings through Zoom became the norm. But if a lawyer or a paralegal conducts a Zoom call, say, from a noisy restaurant or without using password protected meeting rooms, you have unauthorized people who could listen in. And again, that's a confidentiality breach that's just as serious as leaving that file folder like on a bus or something like that. Um, the technology, it does complicate document retention. In the pre-technology world, which was actually not that long ago, I started out working in 2003 and I worked in a very paper-oriented world. But the retention policies were about how long to keep files in storage boxes. And today, it's very different because now it's about managing electronic data, like what stays on a server, what gets archived, what gets deleted. And then you have issues about deleting something too soon. It could deprive like a client of important evidence. Keeping files too long could expose sensitive information if a breach occurs. So it's kind of like a I can't win situation. And for paralegals, these issues are kind of Well, they're kind of pressing because you're going to be the one that's going to be handling the day-to-day use of those technologies. You might be the person who is uploading Discovery to like a shared drive or emailing a client or scheduling the Zoom call. That means that you are going to be the one who's going to be the first line of defense against a breach. Okay. So a simple act like double checking an email address before hitting send or confirming that the attachments contain only the proper documents. And I mean the only correct documents, um, can prevent like a disaster basically from happening. Okay. So, like, if you're drafting a motion and attach exhibits that include like private financial information, you might intend to redact out social security numbers, but maybe you forget. Once that's filed electronically, those numbers become part of the public record. Okay. That's not just a mistake, it's an ethical violation and it can have serious consequences for both the client and the attorney. Okay. But again, the lesson here is clear. Technology, it does make, again, legal practice more efficient, but it also means that vigilance is more important than ever. It really is. And lawyers and paralegals, they've got to balance that convenience with caution. We have to always remember that client confidentiality is going to extend to every form of communication. It does not matter whether it is spoken in the office, whether it is typed in an email or stored in a cloud. Okay, it exists. All right, now let's turn the spotlight specifically to paralegals. While the attorneys are bound by the ABA model rules of professional conduct, paralegals do have their own ethical guidelines that are just as important. Now, these are not abstract principles either. They shape your day to day responsibilities, okay? And they're going to define the limits of your role on the legal team. Now, the first and most important rule is transparency. You have to always make your status as a paralegal clear. That means when you introduce yourself to somebody, a client, opposing counsel, court staff, it doesn't matter. You have to identify yourself as a paralegal, okay? You cannot let someone else believe that you're an attorney, even by implication, okay? This is partly about honesty, but it's also about protecting the client's right to know who's giving them information. All right. So if you have a client who comes in and meets you like in the waiting area and you shake their hand, introduce yourself only by your name, and then you answer questions about a case without clarifying you're a paralegal, that can leave the client thinking that you're the lawyer. And it might feel like it's a very small misunderstanding, but in the eyes of the law, it can be considered misleading and even potentially, it's kind of maybe crossed over into the unauthorized practice of law. Next is confidentiality again. Can't stress this enough. Just like attorneys, you have to protect all information that you obtain in the course of your work. You're going to hear all kinds of client stories. You're going to hear strategies, financial information. You're going to look at financial documents, medical records. Sometimes you'll even hear personal secrets. You're going to learn way more about people than you ever wanted to know. I can promise you that. But none of that can ever be shared, even outside of the team. Okay. The duty of confidentiality applies not just while you're working at a firm, but forever, even if you move on to another job. All right. And the third is honestly probably the most emphasized, and that is you could never, ever engage in unauthorized practice of law. That means you cannot give legal advice, you cannot represent clients in court, or make legal decisions on their behalf. Now, this is one of those areas where it is changing, but we're not quite there yet. Okay. Some states have kind of gotten there, but Georgia's still in the works. But nonetheless, you will have clients who will press you for answers. You have to resist telling them anything, even if you know what the outcome is going to be or whatever the answer is. Don't do it. Don't do it. Okay. You're going to have a client who might call into the office and, maybe they're worried about like an upcoming deposition. And they're like, well, hey, should I answer questions about my finances or should I refuse? All right. That's a question that's asking for legal advice, even if it doesn't seem like it. And as a paralegal, the correct response that you would say is something like, that's something you'll need to ask the attorney. What I can do is explain to you how depositions usually work. Okay. So you can describe the process to them in factual terms, but you can't do anything to make like a strategic call. All right. Another common mistake does happen with legal documents. So a paralegal can draft a motion based on the attorney's instructions, which is perfectly fine. But saying stuff like, if you say like, this is how the judge will probably rule, then you've crossed into that line of legal advice. Okay. You may be able to predict every single outcome. You may be able to interpret the law. You may even be able to know what advice on the strategy looks like. But all of those things are reserved for the attorney only. Okay. And those boundaries are not meant to limit your importance or anything like that. Paralegals are so essential because they free up attorneys to focus on like the advocacy and the legal analysis while you handle the drafting, the fact management, the legal research, client communications, all of those things, but you have to do it within those ethical boundaries. Okay. Line has to be respected. Don't overstep. If you overstep, not only can you be disciplined, in some cases, you could potentially be, held responsible for the unauthorized practice. Supervising attorney, they can be sanctioned as well. Okay. So just remember, as a paralegal, your ethical responsibilities essentially mirror those of the attorney in a lot of ways. Okay. So always stay within the scope of your role. Not a lawyer, and it's not like a weakness or anything. It makes, actually, I think you're more important, just by the way, because the lawyers are essentially arguing your work. Okay, what you do is distinct. It is valuable, and it is indispensable. I forgot there were two more. So let's talk about two more. That's establishing the attorney-client relationship and the accuracy of billing and timekeeping. So let's talk about the attorney-client and relationship and fees. Again, those are decisions that only the attorney can make. So a paralegal should never tell like a prospective client, yes, we will represent you. You also should not quote a fee arrangement as if it was something that was final, okay? You can gather information during the intake interview. You can provide factual details about like how the firm works, but the official decision to take on a client and the terms of payment has to come directly from the attorney. Okay. So if you have a potential client who calls and asks like, what does the firm charge for a divorce case? If you say, oh, well, we charge $5,000 up front and we'll definitely take your case, you've overstepped. All right. The accurate and ethical response would be something like, I can explain how our fee structure usually works, but the attorney will need to confirm the arrangement with you directly. All right. And I know that that's just like, there's a subtle distinction there, but it does matter a lot. And next is the billing and timekeeping. And this is where you're going to spend a lot of time. Okay. And it is one of the areas most likely to cause ethical trouble if it's handled carelessly. So every law firm has to account for how it spends client funds, whether it's billing by the hour or charging flat fees or drawing from a retainer. The accuracy is critical. Okay. Courts, clients, bar associations, they all rely on those records to ensure fairness. So fudging those numbers, whether it's inflating hours, whether it's rounding up time, whether it's double billing for the same task, they can have serious consequences. Okay. For example, there have been real cases where paralegals padded their hours. And then it was discovered like during a client's audit of billing records. The result wasn't just the paralegal losing their job. It led to disciplinary complaints against the supervising attorney because the bottom line is the attorney is ultimately responsible for supervising the paralegal's work. All right. Small accuracies, no matter how small, they can erode that trust. So, if you're billing a full hour for a task that actually took 30 minutes thinking, well, whatever, it's going to balance out over time, the client may never know the difference. But if they do, it does undermine the confidence in the entire firm. Okay. Overbilling doesn't just risk ethics violations. Again, it damages reputations. Now, on the flip side, good billing practices protect both the firm and the client. Some paralegals keep very detailed time logs, kind of open throughout the day. And they enter the task as they happen rather than trying to reconstruct hours at like the end of the week. Okay. And that level of accuracy, it ensures that if a client ever comes and questions a bill, then the firm can give very transparent documentation of exactly what work was done and when. Okay. But the bottom line here is that honesty and timekeeping, timekeeping and billing, like it's not just optional. All right, it's a professional duty. Just like confidentiality protects the client's secrets, the accuracy in billing protects the client's money. And in the eyes of both the law and the public, misusing client money is just as serious as misusing their trust. Now, we're almost finished, but let's wrap up this section on ethics and talk about some things that are of special concern that uniquely apply to paralegals and what they're allowed to do. So, these are the areas where you will often be trusted with more responsibility, but they also do require careful judgment to stay within those ethical boundaries. One area is communicating with the court. Paralegals are generally permitted to file documents and communicate with the court about purely administrative or procedural matters, okay? This means that you can call the clerk's office to ask about filing deadlines, to confirm a hearing date, or to check whether a motion has been entered into the docket. What you cannot do is argue the merits of a case or try to persuade a judge or a clerk on a substantive issue, okay? So if you have an attorney who asks you to call the clerk to find out if something has been scheduled, that's perfectly appropriate. But if the clerk's like, the judge is behind on cases, what's this one about? You cannot start explaining the facts or advocating for why the judge should schedule it sooner. Okay, that's going to cross the line into unauthorized practice of law. Next is giving clients information. And I've already gone over this a little bit, but let me just reiterate this because you are going to be the first point of contact for clients. So you're going to likely be the one who's answering their calls. You're going to be helping them understand the next steps in the case. You're going to be the one who's making sure they feel informed, okay? And you can do a lot in that role. You can explain like the timeline of a lawsuit. You can tell them what discovery means. You can even walk them through like the logistics of a deposition. But the boundary is clear. You cannot give legal advice. You cannot tell a client whether they should accept a settlement, how a judge is likely to rule, or whether they should answer certain questions during a deposition. Nothing like that. And again, you might even, actually, you probably will know the answers to all of those things. But again, those are considered strategic decisions that only the attorney can make, okay? So like if a client calls and says, well, hey, the other side offered me $10,000 if I settle. Should I take it? As a paralegal, you might feel tempted to answer, especially if you've seen a lot of similar cases and maybe this is a really, really good deal for this type of case. Ethically, you cannot, okay? The correct response is, hey, that's a decision the attorney will need to discuss with you. And I'll make sure that they get your message, okay? Again, you can explain the process, like, for example, like how settlement agreements are drafted or how payment is typically handled once a settlement's accepted. That's it. Also is signing the correspondence. Again, the general rule is that you can sign letters or emails to the clients, the courts, or opposing counsel. You have to, again, indicate that you are a paralegal, okay? And the correspondence cannot have any kind of legal advice, all right? So, for example, you might send a letter to a client that says, your deposition has been scheduled for Monday, June 1st at 10 a.m. at the courthouse. You can sign that, but it has to say your name on, your signature line should be like your name, comma, paralegal. All right. That way, no one mistakenly believes the letter came directly from the attorney. All right. Now, here's a word of caution. If the correspondence includes any kind of legal advice or analysis or strategy, even a small hint of it, it has to be signed by the attorney. All right. So imagine sending a letter to opposing counsel, like arguing why the motion should be granted. If a paralegal signed that, it would not only be inappropriate, but it could be considering practicing law without a license. All right. And then let's also revisit the whole, theme of honesty and accuracy. Everything you do as a paralegal, whether filing a motion, drafting discovery responses, or recording billable hours. Again, it has to reflect absolute honesty. So the courts and clients rely on the integrity of the legal system, and the paralegals are key players in maintaining it and its integrity. Okay. So again, you're trusted with significant responsibilities, but you still have those very clearly framed boundaries. Okay. You can file documents, you can communicate with people, you can provide factual updates to clients, and you can sign correspondence that is purely informational. But again, you still have to always identify yourself as a paralegal, and just don't cross that line into giving legal advice or acting as if you're an attorney. So just kind of stay mindful of those gray areas, because they not only protect you, but they do protect, the client that you're working with and the supervising attorney as well. So the moral of the story is that, ethics in litigation isn't just about what happens in the courtroom. It's about every choice that lawyers and paralegals make from the moment a client first walks through the door. Okay. And it governs everything that happens after that, period. So that's pretty much it. Let me know if you have any questions. Bye.